Good morning, everyone. The policies reviewed address various aspects of personnel rights, including age discrimination protections that prevent departments from dismissing older firefighters who can still meet job requirements. While some departments offer rules for senior firefighters, these are limited. Policies also govern employment conditions, personnel care, social media use, and free speech, with violations subject to disciplinary action, including termination. All rules are designed to protect both the department and its members, ensuring only capable firefighters serve the community. These regulations have been thoroughly researched to prioritize safety for employees and the public alike. Employment rights and age discrimination. Fire department policies address a range of employment rights, including regulations that prohibit age discrimination. These rules ensure that older employees cannot be terminated solely based on age, so long as they continue to meet the required standards for firefighters. While some departments provide alternative roles for senior firefighters, such positions are uncommon. The Age Discrimination in Employment Act, ADEA. The Age Discrimination in Employment Act of 1967, ADEA, under 29 USC 623A and 631A, protects individuals over the age of 40 from employment discrimination. A 96 amendment to the ADEA allows state and local governments to set age restrictions for hiring and retirement of firefighters and police officers. Courts have upheld this statutory exemption, so plaintiffs must prove that age restrictions are not being used as a pretext for discrimination. The law is also codified in Public Law 104-208 and 29 USC 623J. Mandatory retirement age such as 63 has withstood legal challenges, including Mintz v. City of Chicago. In 96, Congress reinstated the sunset provision permitting communities to maintain such age policies. Bona fide occupational qualification. The ADEA generally forbids employment discrimination based on age for those over 40. However, employers may justify as a legitimate occupational qualification, considering the job's required duties and associated risks. Specific provisions for firefighters and law enforcement. The law makes exemptions for state and local government employees. It is not unlawful to refuse to hire or discharge someone due to age if the person is applying for or employed as a firefighter or law enforcement officer and has reached the age for hiring or retirement established by applicable state or local law as of March 3rd, 83, or if not hired, the age for hiring in effect at the time per law is enacted after September 30th, 96. Let's talk about facial hair and grooming policies. The fire department often have policies regarding facial hair and beards for safety reasons. Legal challenges to these rules have led to mixed outcomes. For example, in Brian R. Kennedy v. District of Columbia, termination for a handlebar mustache was reversed. However, challenges to facial hair policies on religious grounds have not succeeded, and those individuals were removed from firefighting roles. All departments enforce grooming standards, and failure to comply may result in job loss for safety reasons. Free speech and social media. Free speech. The U.S. Supreme Court has clarified the limits of the First Amendment protections for public employees. In Hefferman v. City of Paterson, 2016, the court reinstated a lawsuit by a police officer punished for picking up a sign supporting a political candidate. Generally, government employers cannot discharge or demote employees for supporting a political candidate. However, in 2006, the Supreme Court ruled that when public employees speak as part of their official duties, they are not protected as citizens under the First Amendment and may face discipline. Social media. Policies extend to social media use. Comments or posts that are hateful, bias, or damage the department's reputation can lead to disciplinary actions, including termination. For instance, in Newton, a firefighter was fired for inappropriate posts about other firefighters. On July 1, 2016, a Freetown firefighter in Massachusetts was fired over a racially charged Facebook post. Many departments now provide sensitivity training to educate firefighters on acceptable behavior. And the International Association of Firefighters, the IAFF, has published guidelines on social media legal issues. Careers in fire and EMS have been negatively impacted by online photos, videos, and written posts. In the city of Newton, we had a firefighter terminated for his post about a deputy chief who had passed away. Promotions. Promotional decisions have been the subject of numerous lawsuits, often involving retaliation for free speech or prior legal actions against the department. The NFPA has put together 3 standards for which departments may use when looking to promote to help assure proper procedures are followed and members' rights are not violated. NFPA 1001, the standard for firefighter professional qualifications. This standard identifies the knowledge and skills required of all firefighters. It is an effective standard for developing an evaluation about a firefighter's ability to safely and efficiently meet the job requirements. NFPA 1021, the standard for fire officer professional qualifications. This standard identifies the knowledge and skills required for fire officers at all levels to perform their job effectively. It is a performance-based standard that can be used to measure the effectiveness of officers. NFPA 1582, the Comprehensive Occupational Medical Program for Fire Departments. This standard is intended to reduce the risk to firefighters by identifying medical conditions that, under stressful conditions, may present significant risks to the health and safety of the firefighter or anyone operating with the firefighter. Each condition is related to specific firefighting skills or functions which the firefighter may be unable to perform. Thank you for your time. Have a great day.